Good morning. My name is Tracy Billows. I am the co-managing partner of Seyfarth Shaw's Chicago office, and I will be your master of ceremonies today. I am so very excited to welcome all of you, both here in person at our office, as well as those of you who are participating through our podcast, to our 16th annual Workplace Class Action Litigation Report rollout. We are so excited to have all of you participating here with us in person as well as watching as we speak. Want to start by introducing our two presenters today. First, we are so honored to have Erin Mulvaney with us today. Erin is a senior legal reporter on Bloomberg Law's labor team in Washington, D.C. She specializes in employment law and covering legal developments around the country that have implications in the workplace, from state laws to the ripple effects of Supreme Court rulings. She previously covered labor at the National Law Journal and the economy at the Houston Chronicle. Erin received her bachelor's degree in journalism from the University of Texas at Austin, and we are delighted to have Erin with us today to lend her insights on the latest key trends in workplace class action litigation. Next, as many of you know, and I have the honor of introducing, Jerry is a partner in our Chicago office and New York offices, and he co-chairs our class action practice group. Once again, Jerry Mattman has achieved a litany of successes at the trial level and in the courts, and still somehow managed to author this wonderful publication that we're going to be hearing some key insights about today. Throughout nearly 4 decades of practicing law, Jerry has secured outstanding results for our clients, defending some of the most significant bet the company type cases ever filed against corporate America, and this year was no different. Defending class actions is not for the faint of heart, and Jerry consistently handles some of the most challenging cases in this arena and the biggest cases in the country. Jerry and his team defended numerous class actions in 2019 throughout the United States. Many of his team members are also here in the room today. Among his various cases this year, Jerry secured multiple class action certification denials, including the first of its kind order for a Fortune 500 company in a wage and hour and collective class action that unilaterally carved out workers who signed arbitration agreements from the definition of the potential class of employees who might ultimately participate in the litigation. He also defeated 2 RICO class actions against large companies that involved potential damages that would have bankrupted both companies had those suits not been defeated by Jerry and his team. Jerry is a prolific writer and is sought out repeatedly as a legal commentator on everything related to class actions, labor and employment challenges that companies and clients are facing, and bet the company type cases and issues. This past year, he was recognized by J.D. Supra as the most widely read attorney in the workplace class action space for his publications and blog postings. Additionally, for the 4th time in 6 years, Jerry was selected by Law 360 as an employment MVP, an award that recognizes the top 5 attorneys in the U.S. for each respective area of law. Given the selective nature of this award, it is exceedingly rare for one lawyer to be selected multiple times in their career, let alone 4 times in 6 years. Additionally, and I'm not sure that everyone has had a chance to see this, just this morning, I saw that Chambers Global recognized Jerry Mattman, commenting in their recognition of him that he is one of the top class action minds in the country. I don't know that I can say much more on this to talk about Jerry's tremendous knowledge, insights, as well as significant achievements in this area. A little bit about the Workplace Class Action Report. As I said at the outset, this is the 16th annual report. It is the flagship publication for our firm and manifests our deep experience and commitment to clients in defending class actions. The report is the sole analysis of workplace class actions from A to Z that you will find anywhere in the country. Clients repeatedly come back to us and say, wow, you clearly are a class act yourself, Jerry and team, for being able to put this together. As Legal Compliance Magazine said of the report, it is the Bible of workplace class action law and a must-read for all practitioners, corporate counsel, employment practice liability insurers, and anyone who works in related areas. At around 800 pages and covering 1,467 rulings, yes, you heard that number correctly, it was profiled in over 1,000 media sources, including Law 360, the Wall Street Journal, the National Law Journal, the New York Times, and Fortune magazine. The research and writing that goes into the report is nothing short of phenomenal. It is done on a daily basis, literally. There are emails being circulated on a daily basis about developments and cases. Our database of cases that we have analyzed over the past 16 years now includes over 15,000 rulings. And this really enables Jerry and his team to spot trends, cutting-edge issues, and look around the corner to see what might be coming down the road that employers need to know and companies need to know in this area. To that end, I'd like to now introduce a short video on the report that we think you will all enjoy. Thank you.
My name is Jerry Mattman, and I'm a senior partner here at Seyfarth Shaw, and I chair our class action defense group. And for the last 16 years, I've been the author and the editor of our workplace class action report and the editor of our workplace class action blog. I'm also an adjunct professor of law at Northwestern University, where I teach trial practice, a position I've held for 26 years. The EPLC magazine calls it the Bible for corporate counsel on workplace class action litigation, and when we initially conceived of it in 2003, it was to fill a void that was missing where a client corporate counsel could go for one place and learn about annual developments in workplace class action. So it started out in that vein, and since has grown over time. We have a database of over 20,000 rulings, and we're able to statistically identify trends, certification patterns, lawsuit filing patterns. We live, breathe, and eat class actions 24/7, 365. We actually review rulings in federal and state courts every morning and every evening, and we create our database and then write an analysis of each particular certification ruling around the United States, and then identify trends for our clients to try and get ahead of the risks that are presented for these sorts of bet the company cases. When our first decisions come out through the end of the year on December 31, and we put those cases, the statistics, the filings in a database to be able to put them in categories and to analyze them. And so it is truly a year-long team event that involves a lot of hard work, but well worth the effort in terms of the sorts of results and analyses and statistical patterns that we're able to provide our clients with in order to get ahead of these bet the company type situations. Okay.
Thank you all. Thank you all so much for your attention to that great video. It is now my pleasure to turn the program over to Erin to kick off our discussion. Thank you, Erin.
Thank you. Happy to be here. I can attest to the fact that journalists reach out to Jerry, by the way. I definitely have to help me translate many of these issues. So I'm part of the team that analyzes a lot of the legal things that happen in the labor and employment realm. So I wanted to go through some of the cases from decisions from 2019 in the Supreme Court that we're already seeing have influence in lower courts, talk about some of the decisions that we expect to come in 2020 that will absolutely have influence on the lower courts as well, and then it was hard to choose, but I picked a few cases and trends that I think would be of interest to talk about. Okay, so I'm going to linger a bit on this because I feel like arbitration, so much of what I do ends up back at arbitration. And these two cases, Lambs Plus and New Prime, really add to a decade's worth of Supreme Court decisions that are influencing arbitration moving forward. New Prime essentially said that independent contractors should fall under this carve-out where they won't fall under the FAA's arbitration, that bolsters arbitration. I have seen New Prime cited frequently by plaintiffs' firms, and in many of the cases, this one's probably the one I've seen the most in other courts so far. It's really it will influence things moving forward. And I wanted to point to, in the Third Circuit even ruled that passengers as well as food delivery drivers who transport food, they can fall under the exception for interstate commerce as well. And that was a really interesting argument, and it's one to watch because arbitration has insulated many companies from class action battles, as we know. So, and that'll be even more potent in states that adopt the ABC test, which I want to talk about a little later. And Lambs Plus, another arbitration case, created a barrier for class action arbitrations, and so this will hopefully be helpful in contract formation, and it kind of removes some of the ambiguity in these cases. So I'll move on to the next one. Home Depot case, it was an administrative one where it was about third-party counterclaims, and it was a question of expanding a 1941 case, Shamrock Oil. And I read the U.S. Chamber's opposition brief, and because they kind of helped explain it, and they basically said that a third party should not have say in the original choice of forum, and not be locked into a state forum of their opponent's choosing. And the court ultimately agreed, and so that'll be influential moving forward and provide clarity in that area. Parker Drilling, I shared this with Jerry before we began. I was the only reporter at the Supreme Court hearing, so I hope that does not mean that it is not of interest to anyone, but this was an interesting one. It's about offshore rig drillers, and the Ninth Circuit decided that the kind of more worker-friendly rules should apply that are in California should apply to the rigs that float off the coast there. And the Supreme Court overturned that decision, but if they had gone the other way and upheld the Ninth Circuit's decision, there was some concern that would apply to the offshore rigs that in the Gulf, which is a lot more, and then state laws would apply to them. And I included Kaiser versus Wilkie on here because it dealt with the hour deference, which determines whether courts should lean on agency interpretation of regulations. Possibly business groups would have liked the standard to be eliminated altogether, but this one's relevant to us in the labor team because the DOL, OSHA, and the EEOC all issue interpretation of regulations, which have been used in litigation. And this ruling certainly weakened the hour deference. So that's something that both the departments and lawyers should probably pay attention to. Okay, so these are the ones that we're watching this year. The first, I don't have this listed on here, but of course the biggest case that we're watching in employment law is whether sexual orientation and gender identity should be protected under Title VII of the Civil Rights Act. That highly anticipated ruling will be interesting to watch play out. I attended that hearing as well. And I just wanted to point out, I think something that'll be interesting for the workplace is a lot of the justices asked questions about bathroom and dress code policies, specifically with the transgender question. And I think that'll be something that'll affect the workplaces however this decision comes down. And of course, I'm not going to make any predictions, but we're waiting for that decision in the LGBT Title VII cases. And the next two cases are about but-for causation. And the first is Babb versus Wilkie. And I think that Justice Kavanaugh called this the OK Boomer case, if anybody follows oral arguments very closely. But this will solve an appeals court split on the causation standard for age discrimination complaints under the Age Discrimination in Employment Act for federal workers. And so it'll obviously either make it easier or harder to prove if there is age bias, be it but for or motivating factors. There was an interesting back and forth on this issue. The court asked the DOJ, which is representing the government because it's a federal government case, and the workers' attorneys to provide supplemental briefs. And the DOJ had a pretty remarkable materials arguing that federal employees already have other ways to file age bias claims outside of the ADEA. And so that's a pretty remarkable document if anybody likes to dig into Supreme Court dockets like I do. And the next case actually revolves around a Reconstruction era law that is often filed around Title VII claims alongside Title VII claims, and they're analyzed similarly. It's not an employment case, but I think this could affect workplace decisions moving forward. Comcast wants but-for causation as opposed to motivating factors to be used to analyze a race discrimination claim brought by an African-American owned media company. And so those will be very interesting. And we see a lot of but-for causation cases and those questions in lower courts as well. So these are both poised to provide some clarity there. And the next one is, it's actually a pair of cases. I listed Our Lady of Guadalupe School, but they involve two different cases where Catholic school teachers attempted to file disability and race claims, respectively, and the schools argued that they should fall under the ministerial exception for claims, which means they're not allowed to file these suits. And so it'll be really interesting to see how the Supreme Court comes down on this, and whether, because it could potentially expand what is considered a religious job duty, and I just find any kind of clash between religion and discrimination extremely interesting. So I think this case has not been heard yet. It will be heard on April 1st, I believe. So that brings us to some of the topics that I chose as employment trends, and I feel like the question so far this year seems like a very basic one. Who is an employee? But it seems to be very complicated in a lot of the litigation that we see. A lot of the litigation we've seen at the beginning of this year, we're focusing on the ABC test in California, and in other states that use this higher standard for determining who is an employee or an independent contractor. And a lot of the business community has been stressed out about this and kind of deciding what to do if they're gonna, because what it's in even franchisees or joint employer relationships, they're kind of wondering how they fit into this new stricter classification. And meanwhile, progressive states are following suit. The ABC test has already been met with challenges. Gig economy companies, Uber and Postmates, are trying to challenge it, and they're also pushing for a ballot petition to try to overturn the law. There are freelance journalists who sued against the law, and successfully the trucking industry filed a they actually successfully got a preliminary injunction against the law for now, having a unique argument. And these laws are really focused on, I think a lot of people see them as anti-gig economy laws, but I think they're really affecting janitorial companies, they're affecting construction workers, I wrote a story about strippers who are going to be affected by this, I'm not joking, and it'll really be a test for a workplace that some people call a fissured workplace, where a lot of employers subcontract out a lot of their work, and there'll be kind of a reckoning for that. And so that's why I mentioned the joint employer issue, because 3 agencies are looking at this right now. The Labor Department, the NLRB, and the EEOC are studying how to address joint employer issues. And so I think that's definitely going to be a major theme moving forward and something to pay attention to. This also dovetails with my next topic, which is arbitration again. And actually, just this week, we covered a story where more than 5,000 DoorDash couriers will all be entering at once. They were compelled into arbitration with. At one, they'll have 5,000 individual arbitrations at once with DoorDash. The judge actually ruled against DoorDash in this, forcing them into arbitration as opposed to halting it. This was the latest example of a court forcing this issue for arbitration that a company asked for, and plaintiffs' attorneys do, I think, have a hard time getting all of these demands at once, but they still, when they do it, there is a lot of pressure on the company to pay that at once. I believe the bill for the filing fee for DoorDash was going to be about $10 million just to start the process, and that doesn't include, of course, for each individual arbitration, it could be up to about $10,000 each. And so I think this is a pretty good way to either force a settlement or not. And we've seen it. Uber reached a huge settlement last year in this. And so I think that kind of tactic is something that will move forward as a lot of these companies use arbitration agreements or prefer arbitration, but then are faced with somewhat of a class action on their hands, but maybe in a more difficult process. And so I just thought I should mention 2 cases that I have listed here that were both issues of first impression, both in the Fifth Circuit and the Seventh Circuit. And they raised the question of when notice should be given to the workers in a collective action if they have either signed arbitration agreements or the company claims that they should be taken from the group because they have. And they were slightly different cases, but they were both issues of first impressions in these appeals courts. And I will be curious to see if more come forward in these. So I just wanted to talk about 3 more topics. I've been very interested to cover, and there was this issue almost made it to the Supreme Court last year about the salary history bans. A lot of workers' rights advocates and the EEOC say that employers' practice of asking salary history to hires can further perpetuate the cycle where women and people of color make less money than their white male peers. And so Philadelphia made its way up to the Third Circuit, and its law that bans employers from asking job applicants about their salary history will move forward for now. And this could potentially, people I talked to for this story said that could, bolster similar measures around the country that are aimed at targeting these pay gaps in the workforce. And that was so that'll be a really interesting topic to watch, because that could have been a difficult case for them to win. And there are so many states and cities that are adopting those laws. And so if there's a challenge, they might be able to point to that Third Circuit decision. Similarly, we see a lot of pregnancy discrimination cases and how to deal with that. I would point to a case in the 11th Circuit. There were recently oral arguments at a federal appeals court in Alabama. And the question is whether an employer can categorically deny pregnant employees accommodations. And it provides a test to a Supreme Court case, Young versus UPS. And I just think it's one to watch because it'll test an important issue, and we really do see a lot of these cases in the lower courts. So we don't know if it'll maybe make its way up higher. But and then the final one is, again, it seems a little wonky, but these three cases that I have listed here, I'll mention one about there's going to be a decision on it. Whole Foods is attempting to impose a strict jurisdictional rule to stop class members with no connection to the place where the lawsuit was filed from pursuing the claims for unpaid wages. So depending on how these decisions come down, it could essentially add restrictions on nationwide class action. So I think it'll have there are three cases, so I feel like the issue is ripe for exploring and paying attention to. So,
Great.
yeah.
Okay. Well, my name's Jerry Mattman. It's an absolute honor and privilege to be with Erin. I read her every day, and for all of us to be able to hear her insights of all the things across her desk and the trends that she sees across the United States, I think it tells us a lot about where we should focus our compliance efforts, what's hot, what are the areas that are going to impact the workplace. So thank you so much for gracing us with your presence and your ideas. And I'm also very pleased to be here today to see both friends and clients that I deal with on a daily basis. And thank you so much for taking time out of your busy schedules to join us here for our fourth annual book launch for our 16th annual report. So as the video clip had indicated, we review cases every morning that are decided the night before, every night for cases that are decided during the day, both in state and federal courts. And we have a team of lawyers that are looking at these rulings and categorizing them and analyzing them, trying to figure out what they mean. And it is a big job, and there's a lot there. This year, something did not happen that happened the year before. There were two federal judges, believe it or not, who issued decisions on Christmas Day in 2018. We didn't review those till December 26th, but this year we had no holiday rulings. But in the book that's on the tables, a good 10% of the rulings are from the month of December, and a good percentage of those are from the last week of the year, when courts are cleaning up their dockets and issuing their rulings. But our method is to try to break down all these rulings, discern trends, identify issues that can help clients comply. It's better not to be a defendant in the case and to spend $1 on compliance than $10 or maybe $100 to defend yourself. I teach at Northwestern. I've been there quite a while, and the law students there read their law books and learn about the case or the company. And no company wants to be known as the case or have its name attached to the case. Far better not to be a defendant in one of these cases. But what we did is we distilled those 1,455 rulings from 2019 and tried to break them down and say, what does this mean? What does it mean today? And what does it mean in terms of what's occurred in the last decade? So I chose 5 trends, 5 themes that I think are very, very telling for corporate America, for what to keep your eye on, what's evolving, what's happening, and what probably is going to be the future of both compliance and litigation trends. And so I'd like to, in the next few minutes, kind of take a tour of those 5 trends and break them down statistically and show you what occurred throughout the United States, both in federal courts and state courts last year, to try and give you some insights as you leave today on what can I do at my company to stay ahead of these problems, get out ahead of them, diffuse them, and make sure I have a better workplace and that I'm not a party to one of these cases. So the very first trend involves certification of class actions in federal and state court, and we broke these down by circuit. We looked at all of them. There were 303 last year in federal courts, and by and large what it showed is plaintiffs, workers, do better than defendants or employers and more cases get certified than those that don't. There are certain areas of law where employers do well. Employment discrimination is an example, but there are other areas where workers or their advocates do better, and wage and hour is one of those areas. And as the statistics bear out, there are certain what I would call hotspots or magnet jurisdictions where employers get sued more often than in other areas of the country. And those traditionally have been and continue to be in 2019 on the left and right coasts in what's known as the Second Circuit, which is centered in New York City, and the Ninth Circuit, which is centered in California. The court sits in San Francisco. And by hook or crook, the manner in which judges in those jurisdictions approach issues in these sorts of cases tend to favor plaintiffs, tend to allow advocates for workers to certify their cases and to achieve better results than in other areas of the country. So not unlike selling your home, location is everything. And if you're in the Second or Ninth Circuit, workers seem to have an advantage as compared to employers. But there's more to that in the trends. And so one of the things that was also important is if you're an employer, what are you apt to be sued over? I would have answered that question in 2010 by saying avoiding discrimination. I would answer the question today in 2020 by saying it's how you pay people. The number one area where lawsuits are brought is in compensation and pay decisions. From 1998 to 2015, wage and hour cases increased every year in federal courts. It was like a wave that never crested. And in 2016, for the first time in 16 years, there were less cases filed. And in 2019, we now experience the fourth year in a row with a decrease in filings. Nonetheless, still a lot of cases, and nonetheless, over 90% of the certification decisions involve wage and hour areas. But more definitely, we're on the downward trend of a bell jar curve where there are less lawsuits. Now, what would you attribute that to? My personal belief that it is somewhat a symptom or a manifestation of the Supreme Court and its decisions, particularly in 2018 in the Epic Systems decision, which greenlighted the use of workplace class action agreements that have what are known as class action waivers. It is a contract or a form of a contract, could be a two-page piece of paper, more likely than not, entered into at the time that an employee onboards at a company that basically says if you have a grievance, you cannot bring a lawsuit, rather you bring it in arbitration, you bring it on behalf of yourself, not on behalf of a class, the so-called class action waiver. What I see and what I see clients experiencing is instead of being on the receiving end of a lawsuit these days, they'll get a demand letter from an attorney, or an attorney will file an arbitration claim on behalf of one employee. I think that is probably the number one reason why you see the declining number of FLSA lawsuits that are filed. 99% of those lawsuits are filed as class or collective actions on behalf of multiple people. The arbitrations are brought on behalf of typically just one person. So as we open the new decade, what can employers expect to see in 2020? Well, we don't know. One adverse data point would be a raising of the minimum wage in over 20 states. What does that mean? It means the amount of damages that one can recover will be greater in 2020 than in 2019 because the measure of damages will increase. What we have seen with a decrease in federal court filings is an increase in filings in state court in states such as California, Massachusetts, Pennsylvania, New Jersey, Michigan, and Florida. Why those states? Well, those states have longer statute of limitations, more generous damages remedies, And plaintiffs' lawyers know they can recover more in state court than they can in federal court under those state laws. So the Supreme Court take it away in one area, and plaintiffs' attorneys nothing if not inventive in terms of figuring a workaround. So kind of net, I think the same amount of litigation may be filed. The numbers might, again, be a little lower in federal court, but because of the rise of the minimum wages, the issue over the joint employer rules that Aaron talked about, more entities being sued over a wage violation than before, not one employer, but maybe multiple employers, and the Trump DOL. As we'll talk about with government enforcement litigation, the federal government is in the business of filing less lawsuits today than before, and where it files less lawsuits, the plaintiff's bar tends to fill that void. So the jury's out as to what will occur in 2020. Certainly, I think that lawsuits will continue to attack the way in which employees are paid or independent contractors are paid. The issue will be, where are they going to be filed, in arbitration, in state court, or federal court? My prediction would be less in federal court, more in state court, and certainly more in arbitration. Another trend to take away is what I call an indication of what I would describe as the stock market theory of litigation. I cross swords with very talented plaintiffs' lawyers that come from different walks and areas of life and law, many of whom used to file securities fraud, director and officer litigation, and have now kind of migrated to the wage and hour space. Why? Success begets copycats. We'll talk about some of the larger settlements and the ability to convert lawsuits into certified cases, which is the holy grail in this sort of litigation. Once a case is certified, it tends to settle because of the hydraulic pressure imposed on an employer dealing with a large piece of litigation. And so in essence, you have many, many skilled lawyers on the plaintiff side rushing into this space. The barriers of entry are very low. All they need is one client in a wage and hour case paid on a common payroll system. They don't need a plaintiff's expert like in an employment discrimination case. A statistician might cost them $250,000 to come up with a report, or a labor economist in an ERISA case. And within 1 month to 3 months, they could certify their wage and hour case with a very low minimal investment of time, yet a high return. Hence why the way in which you pay people still is where the rubber meets the road, where the most plaintiffs' lawyers are attracted to suing companies. But for the first time in 2019, we saw a different trend than we saw in the past 9 years. And that was, besides the Second and Ninth Circuit that I talked about before being the magnet jurisdiction, now the Fifth down in the Texas area and the Sixth in Ohio were equally populated with cases as compared to the Second and Ninth. In essence, both coasts moved to middle America in terms of the volume of filings and the settlements, so that was a geographic shift that we hadn't seen before. My personal take is you have more lawyers in cities like Cincinnati, Cleveland, Nashville, Houston, and Dallas filing wage and hour class actions than ever before. And they used to be filed in New York City and San Francisco. So you're seeing the development of the case law in those circuits at an increased or enhanced basis that we didn't see before. So again, like real estate, location is everything. And statistically, what was borne out in 2019 was middle America was an area where plaintiffs' lawyers were filing lawsuits and certifying cases like never before during the period of the decade. So the next slide to me is the most striking, 81%. A little more than 8 out of 10 motions that plaintiffs' lawyers brought to certify their cases in the wage and hour area were granted. That is the single highest figure in the last 10 years. It had never been over 80%. You can see the slide on the right, and they were in the mid or high 70s, but this was the first time it ever went over 81%. So these cases can be won. These cases can be defeated. Depends on the case, depends on the judge, depends on the jurisdiction. But by and large, that's another factor that's attracting many of these plaintiffs' lawyers into the area where they know that statistically they stand a very, very good chance of certifying their case. So what happens next? And you see that figure of 58% and 42%. That's what's called a decertification process. After the judge would certify a case, the judge would say, now I want the parties to undertake discovery, come back to me in a year, 18 months, show me all the evidence that's been accumulated, and I'll decide if whether based on all that evidence, the case can still truly go forward as a collective action or class action. And there, employers are winning 6 out of 10 times. Employers are doing very well. The rub or the problem is the cost. The cost of getting from the first certification ruling to the second certification ruling is immense. What's the cost? Looking at all your servers, pulling down all your email, pulling down all your documents, all your payroll people, your HR people, having to go through depositions on a nationwide basis in some of these cases. So a lot of cases settle between 81% and 58% because employers say it's just too costly, too difficult. I'd rather spend my money to get rid of this case than to litigate it. But those litigating it, because of the compliance procedures ongoing at these companies, stand a pretty good chance, 6 out of 10 times, to decertify that case, and it's basically vaporized. It goes away. And all those people who opted into the case are basically kicked out of the courthouse, and there's only one person left. So the 58% pattern was a little higher. It's not as high as it was a couple of years ago. It's 63, but it's showing that employers doing a good job with compliance, and if they play out the string, can do very well. The last slide talked about the other spaces we looked at, which is ERISA over pension plans, retirement plans, or employment discrimination, gender, race, national origin discrimination. For every 10 wage and hour cases filed, there's probably one ERISA case filed or one employment discrimination case filed. And what a difference a couple of years make. If we had this presentation in the year 2012, the year after the seminal ruling known as Walmart Stores versus Dukes, where the Supreme Court ratcheted up the standards to certify a case under Rule 23, that percentage under both ERISA and employment discrimination was in the 20s. I've seen it as low as like 19. Well, what's occurred since 2012? How come it's up at 64 and 65%? I would say this is what I would call 2.0 lawyering by the plaintiff's bar, reinventing their theories to adjust to these new standards erected by the Supreme Court. And so what we're seeing now is smaller size cases attacking one discrete employment practice, such as an application on an onboarding process where an employer asks for a criminal background check. And there'll be a Title VII lawsuit saying that that has an adverse impact on minorities, and there's no business justification for ascertaining whether or not somebody has a criminal background because that has no bearing on their performance in the workplace. Or a case against promotions in one plant that might involve 335 people rather than the Dukes case that involved 1.6 million females at Walmart seeking promotions and pay increases. So seeing a downsizing of the cases, smaller, tighter, designed to try and secure certification, and that has driven the percentage up. We're going to show you conversely in some slides what's it's done in what I call conversion in terms of the value of these cases. But by and large, in 2019, the plaintiff's bar did better in any year of the decade in terms of their 81, 65, and 64 percentage points in terms of certifying their cases. Trend 2 that I selected is the Supreme Court, and I don't want to go over what Aaron so ably mentioned to all of us, but I believe, compared to the beginning of the decade, the court certainly is more business friendly now than it might have been before. When it comes to an arbitration case, I think most employers win arbitration issues by and large at least 5-4. And I would characterize cases as either door openers, the court opening the door to federal courts, making it easier to sue or easier to certify their case, or a door closer, making the standards higher, making it more difficult for lawsuits to be brought. And what you saw in terms of the last decade were 3 cases. I've listed 2 of them, the Dukes case in 2011, the Comcast case in 2013, and then the Epic Systems case a year and a half ago in March of 2018. All 3 of them are door closers. All 3 of them make it more difficult to bring workplace class actions. All of them erect barriers that workers, plaintiffs have to jump over and basically make it easier for employers to defend themselves. So as we saw with that percentage this year in terms of the plaintiffs' bar adapting to Dukes, you're going to see the plaintiffs' bar adapting to Epic Systems. Aaron talked about the DoorDash model and what's going on there. So who knows what's going to bring in the next decade, but it's if you think about a pendulum swinging from left to right, that's probably what we saw in the last decade. Employers doing pretty well now, but yet plaintiffs' attorneys certifying cases at the highest rate ever. So go figure. It's a little out there. So I'd like to go now to trend 3, which is government enforcement litigation. And I think that basically what you can say is it's fallen off the cliff. And finally, the Trump administration has effectuated its goal to ratchet down government enforcement litigation. So for the EEOC and the Department of Labor, the rate and volume of lawsuit filings is way down. There was a 30% reduction last year as compared to 2018. The recoveries were down a little. There's a map here. It's kind of hard to read the numbers, but think about how populated the state of New York is. And there were 3 lawsuits filed by the government in the state of New York, 3 in Texas, 1 in Michigan, 2 in Pennsylvania, none in Arizona, none in the state of Washington. California had 11. Maryland, of all places, had the second highest number, 6. So litigation filings by government enforcement lawyers have a little bit more to do with the individual proclivities of the district offices of those government offices than it has to do with the national plan, other than the watchword of settlements are down. Next trend would be about the timing. I think many in this room know that the fiscal year for the EEOC ends on September 30 of each year, and it measures its lawsuit filings from October 1 to September 30. Last year, 52 lawsuits, more than a third, were filed in the last 20 days of the fiscal year. What types? Gender discrimination and ADA. So if you really drill down to what is the pressure point for an employer right now, it is how you handle accommodation requests for employees with a disability and how one handles workplace harassment issues. Other than the way you pay people, these statistics show those are the 2 areas where the government is most apt to have an employer on its radar in terms of what it's looking for when it is deciding whether or not to sue a private employer. I handle cases brought by private plaintiffs' lawyers. I handle cases brought by the government. Cases brought by the government, much, much different. I would describe it as akin to holding a tiger by the tail. Very, very aggressive, has the full weight of the government behind it, somewhat of an unlimited budget, and kind of the notion of we do it because we have the power to do it and we're going to do it and we don't have to explain ourselves to anyone. So although there are less government lawsuits, they tend to be very, very difficult ones. My prediction would be in 2020, we're going to see less than we saw even in 2019 when they were down. And until there is a new occupant in the White House, maybe from a different political party, and less than until that occurs, I do not see governmental litigation ratcheting up. But to the extent there is any, it's going to be, next slide, the area for this issue that I'm going to talk about now, which would be low settlement numbers. Settlement numbers, I think, pivot off Dukes v. Walmart and what occurred back in 2011. But this bar graph shows the declining values. This last year was kind of flat, but basically I think Epic Systems and Walmart made it more difficult to carry through cases all the way to trial. Remember that 58% bar even in wage and hour cases where employers were successful. So basically the amount of money that plaintiffs' lawyers are able to take out of the system is less. The next slide breaks it down in between the various areas, and there were only two areas last year that were up: wage and hour, which nearly doubled, almost $500 million, and ERISA, which went up. Employment discrimination way down. Government enforcement litigation fell through the floor. So why do we track settlement numbers, and what do settlement numbers tell you? You can go to the next slide with the low settlement numbers. Yesterday, I was in an all-day mediation in a class action involving privacy. In the first 15 minutes of the mediation, the plaintiff's lawyer said, Facebook just settled a similar claim for $550 million this month. That now sets the bar to the value of these sorts of claims. So these leading settlements that we track and follow kind of set the market, or at least the opening negotiating ploys of the plaintiff's bar when they walk into the mediation, when they say, this is the going rate or the value of these cases. So knowing what these leading settlements are, or if settlements are down or up, certainly is very important. And as you can see here with employment discrimination, plaintiff's bar not doing so well. It's a declining value. The largest one this year was the Wynn Resorts case involving a claim against the board of directors in a Me Too type situation, but that was under $100 million. And we haven't seen a $100 million settlement for about 5 years in this particular area. The values are going down. Next slide shows what's going on with the government. This was the third lowest year in the entire decade, and they fell through the floor. The DOL, the EEOC, recovering less and less money, down from $485 million to $57 million in the space of 24 months. The largest settlement the government secured last year was $9.95 million. So the going rate, so to speak, in the employment discrimination area and in the government enforcement area certainly are declining values. Last trend I think has to be the Me Too movement. It wasn't a fly-by-night passing social phenomenon. It's here to stay. It manifested itself over the last 12 months with a series of laws passed at the state level regarding non-disclosure agreements or non-use of non-disclosure agreements, mandatory workplace harassment training laws, more teeth in damages remedies, and we're still just seeing now all the lawsuits that have been brought. And just this week or early next week, there's going to be a verdict in probably the most high-profile case that started the Me Too movement that's going to be in a New York State courtroom in Manhattan that will probably put the spotlight of attention on this issue all over again. The EEOC has hitched its star to the Me Too movement, and this bar shows the number of cases. At least last year, there were 28 of them. And so if you have a Me Too situation in your workplace, it's probably the number one area that the EEOC will be looking at in calendar year 2020. Again, nothing new to the ears in this room about the importance of solid HR administration and dealing with these sort of issues before they get out of hand. So that's a very quick tour of 1,400 cases and what's going on in the workplace class action world. The issues are very different in 2020 as compared to 2010. I hope my goal is to be here in 2030 and talk about what they're going to be 10 years from now. But I think despite how much things change, the fundamentals remain the same. Ensuring workplace due process, having great policies and procedures, and implementing them in a non-discriminatory, consistent fashion is the best preventive medicine that I can think of to eliminate these problems, so that you're not dealing with Seyfarth Shaw about this issue or defending these cases, but rather can read about what's going on. So thank you all. It's a lot of fun talking about these issues.
Thank you, Jerry. Thank you, Aaron, so much for that wonderful presentation. We have about 5 minutes. We can open it up for questions. I know a couple came in from some of the people who are participating remotely. Jerry, one question for you related to government action and seeing what you're seeing from the EEOC. Someone in California wants to know, which you know is a hot state as well for these issues, are you going to also see some of these states who've been passing a lot of these laws in response to Me Too starting to look to be as aggressive as the EEOC is in either their enforcement actions, potentially trying to file lawsuits again where allowed under the state statutes, which we all know they do differ from state to state. But what do you think you might be seeing from the states is what people are asking?
Great question, and it depends on your state. If you're in North Carolina, probably not a lot to worry about. If you're in California, New Jersey, or New York, plenty to worry about. For the very first time, the California Department of Fair Employment and Housing last month filed a motion in a private class action that had settled for $10 million. The reason it did is he said, the California agency said, that is not enough money. Those workers have been sold out by their lawyers. We as the state want to block the court from approving that settlement. We think it should be triple what the employer has agreed to pay to settle this case. Never seen that before. So to the extent that the California agency is going to begin to monitor private litigation and opine as to what the value of the case should be, that's a dramatic departure from anything we've seen before. In New York, we all lived through the Elliott Spitzer era. That's starting up again, and so I think that there are select states with strong attorney generals and strong agencies, or a system, a court system that allows for it, where you're going to see some activism. Where the EEOC doesn't, you're going to see the void filled by those state agencies.
Thank you, Jerry. And I know there are a lot of people out there that have questions, and I know that Jerry will do his best to get them all answered after today's program, because as you can imagine, there's just no way we can get through those. But I did want to open it up to everyone here in Chicago to make sure we've got time for one more question if someone here in Chicago wanted to raise a question. Yes, please. I'll bring you the microphone.
Aaron and Jerry, thank you so much for your comments today. Really appreciate it. Jerry, this is directed to you. Given what you've seen in class actions and collective actions in the wage and hour space over the last year, what would you advise your clients going into 2020 are the three hottest areas in their compensation practices that they need to audit and pay attention to?
Good question. I think one is how you classify people in terms of what they do and whether or not it's appropriate that they're exempt or non-exempt from overtime. The second would be the use of independent contractors, that simply having someone sign a document where they confirm that they are indeed an independent contractor is not so useful in a lawsuit, and it's really a facts and circumstances test in terms of what they do. And then bonuses or commissions, because the minutia of state laws that impact on the way in which bonuses and commissions are paid. You can have a company operating in 50 states that is subject to 50 different and conflicting interpretations on bonus and commission payments. I think it probably is why in many large companies there is a full-time lawyer on the in-house counsel staff that is in charge of just payroll compliance issues. It's not going away, but those would be the three areas.
Thank you very much, Jerry, for answering that. We really appreciate it. We may have time for one more quick question here in the room. Anyone have a question that they'd like to raise? Yes.
Thanks again, Jerry and Aaron. Quick question directed at both of you. Now that the ruling at Epic Systems has really taken hold and the use of corporate arbitration programs has expanded, what's next for workplace class action? In particular, what's next for the plaintiffs' class action bar in terms of where they're going to go?
Well, I do think it's a strategy that they could do these mass arbitrations that I mentioned, and almost like saying it's a class action and calling the employer's bluff on whether or not they really want to go through that many individual arbitrations as opposed to class actions. I think honestly those are a way to pressure settlements. I don't know if Jerry would agree with me, but I don't know if it's practical to actually go through 10,000 arbitrations. But that's honestly one scenario, but I think also for the plaintiff's bar, that's still not easy. The class action would still be the preferable route if it's possible, but employers do have a lot more power by being able to insulate themselves with these agreements, and those agreements have a lot more power the more the Supreme Court bolsters them. So
I'd say net, employers come out miles ahead using the workplace arbitration agreement. They're going to be DoorDash situations where it might break down. I think that if the White House and the Senate change political parties, the very first set of bills is going to include a bill to overrule Epic. I think it'll be signed. I've never seen louder, more sustained and aggressive lobbying on that issue. Plaintiffs' bar basically has said we need to eliminate that. I think the area that is going to be hot over the next couple of years is use of artificial intelligence in the workplace privacy, and integrity of workplace data. And you can see the plaintiffs' bar branching out into that particular area and filing many more lawsuits than ever before.
Thank you, Aaron and Jerry, both very, very much for your wonderful insights. And thank you all for your participation today, both those here with me in Chicago and those in many, many other places outside of Chicago. We're so grateful to have all of you. And I would just want to give one big last round of applause for Aaron and Jerry, thanking them so much.
Thank you. Great job.
Have a great day, everyone. Thank you again.